for a second. Okay. Hello, everybody. So we're doing a quick. You sure? Because the green things are saying that it's on. Yeah, it's on. From what I can tell, it's on. I clicked on the thing on the YouTube, like the microphone icon. Should I go into settings? Yeah, both mics are on. You still can't hear me? No, I just did that. I had it unmuted before. Say something again. Can you hear me? Can anybody hear me? Oh, it does? All right. All right. We'll edit this out. We'll edit this out. Okay. So is this your official entrance? Oh, okay. So this is my my co-host, my moderator. This is Tori. She's going to be joining me this evening for this class. See, there she is. So Tori, welcome aboard. This is STEPP, Stabilizing Tenancy Eviction Prevention Program. So today's going to be a whole lot of fun. Tonight we're going to be talking about, what are we talking about? We're talking about ending or breaking your lease, so lease termination. So again, welcome to STEPP, Stabilizing Tenancy Eviction Prevention Program. So STEPP's an acronym, and this is a great class. It's been given to us. Funding has been provided for this class from the New Jersey State Bar Foundation to teach landlord-tenant courses, and that's what we're doing here tonight. So we are continuing along with that. So what I'd like to do before we get into the nitty-gritty, Tori, if you don't mind, could you? Yes, because every time I do it,
I'm also the tech person.
Yeah. So every time I do it, I end up messing up the video.
Oh, I knew it was gonna do.
Oh, let me make sure I got it. There you go.
Undo those. All right.
So this is what they can see.
Yeah, they're seeing two cameras of.
Okay.
Oh no, my little ghost.
Okay.
I'm gonna go check to see it's working on live stream.
Okay. So bear with us for just a second. For those of you who are joining us this evening, this is STEPP. It's our landlord-tenant law series. So STEPP stands for Stabilizing Tenancy Eviction Prevention Program, which you can see from our first slide. Tonight is course 6. So we're going to be doing lease termination. Tori just stepped away for a moment. We're just, we're doing a live stream here. So we just want to make sure that the slides, you guys can see them okay. So it looks okay? All right, looks okay. Tori did a great job. Thank you, Tori. Thank you to Tori. Oh, and she dropped her mic. But go ahead. I would clip it. Try to clip it like kind of low so that because I think when you hold it too close, it's you're gonna want to make people's ears bleed. But I'm the loud one, right? So Tori's here. She brings a very calm, mellow vibe to my like intense landlord-tenant presentation. So hopefully this will make it more
Maybe
palatable, a little more enjoyable for everybody. You get a nice co-host, and you get to enjoy the material a little bit better. So Tori, thank you for joining us. So Tori is our fundraising coordinator. She's also the tech guru in this.
And media personnel.
That's right. So she does a lot here, and thank God she's here, because every time I'm alone, I can't seem to quite get the tech right. So either you'll hear me and there will be no video, or like it'll flash in and out. All of a sudden there'll be a cartoon version of me, then it'll be a regular version. So so there you go. So as we jump into the actual substantive material, oh, and to let you know, tonight we're actually be joined by a guest speaker. His name's David Saltzman. He's an attorney. I think he's a managing attorney. From, what do you want? Oh yeah. So how do I get through the slides? Oh, thank God. So again, this is STEPP. Thank you for joining us. And what we're going to be doing tonight is breaking or your lease. So before we jump into the actual substantive material for this evening, we want to just let you know that we have a disclaimer up front. So the first thing we always let people know is that we are not attorneys here at Family Promise of Sussex County. So we've got some great programs that are based in the court system. So for some of our clients who might be enjoying this material, we have a program that's called Comprehensive Eviction Defense and Diversion, or it's called CEDD. We also have Homelessness Prevention Program, which is also if you have a docket number or if you're facing eviction, those are some programs you might want to call Family Promise about. And those are in the court system. So you may have seen me or some of my colleagues in the court before. And that experience has kind of lent the ability for me to learn some of this stuff and to teach the coursework. But we're not lawyers. So that's the important thing. We're not attorneys. We can't give you legal advice. No. So, but that's why we're bringing David on. That's why we're bringing, yeah, exactly. Let's not get into that. But David is an attorney. He's a barred licensed attorney. So he is qualified to give responses that are of legal consequence. So I cannot give you advice, but he certainly can. But so this series is simply informative. And the reason why we're doing it is because it's tremendously important to know what your legal rights are and to arm yourself with the most knowledge that you can. So there's a couple reasons. One of them being that we're trying to promote more peaceable, community-based, just better transactions amongst landlords and tenants. So they don't have to go to court.
We're trying to make the process easier for everyone.
Exactly. So you don't have to go to court. You don't have to, you can know what your rights are ahead of time, so that landlords, they are more apprised of their tenants' rights. And likewise, if you feel that your rights are being infringed upon, you'll actually know the law a little bit. So this isn't meant to be a law school course. We're not delving into too much. We're not getting into specifics. We're going to brush with broad strokes and give you some general information how to represent yourself. Because the other point of this is that early intervention is always the best key when it comes to getting legal representation. One of the most common things we see in landlord-tenant law is the inability to pay your rent. So one of the reasons why the most common thing we see in the courtroom is non-payment of rent cases. So if you can't pay your rent, the likelihood of you affording an expensive attorney is going to be probably pretty limited as well. So, and your constitutional right to an attorney. So like in criminal law, if you're in court for a criminal case, doesn't happen in civil cases. So in so apparently they're talking about it right now. They're talking about making it in New Jersey a constitutional guarantee to legal counsel in landlord-tenant law. So that was a little tidbit that was shared with us by Sarah Webb, one of my guest speakers for rent increases. She said that there are talks about it right now, but it's still not the case. It's not on the books. But eventually down the road, that is something they anticipate hopefully being. But right now, so in criminal court, you get it if you can't afford attorney, like when they Mirandize you and they say in those cop shows, if you can't afford an attorney, one will be appointed to you. Not the case in civil trial. So that's why so even if you can't get in with legal services, there's no guarantee they can always take your case. We always encourage you, go early. The moment you are struggling to pay your rent, or you're having an issue with your landlord, you're feeling intimidated, you're feeling threatened, that is the time to get involved with legal services. Don't wait until it's too late. But in the event, let's say they are unable to represent you because they have too many cases or for whatever reasons, it's important to have this information available so that you're better informed, you know your rights, and it's good to just have it in your back pocket so that if you do go into a conversation with a lawyer at legal services, you can intelligently discuss the topics and know which are legal issues, which are other issues, and things like that. So there's a bunch of reasons why we're doing it, but before we jump into that material, again, just wanted to say thank you, really, just with a lot of gratitude and sincerity to the New Jersey State Bar Foundation for allowing us this opportunity to teach these courses. This is a grant-funded, program from the NJSBF, and we thank you very much from the bottom of our hearts from Family Promise. Thank you. So again, as you can see from the timeline, we've already taught several courses, and then today is going to be lease termination. So our guest who's joining us again is David Saltzman from Legal Services of Northwest Jersey. So he's going to be joining us virtually. We have a link. He's going to be joining us via Teams, and he's going to let me know when he's coming on. He's running a little bit late this evening, so we're going to go ahead and jump right in, and then he is going to join us for tonight's program. So really excited to have David join us. We'll have some great questions for him, and he's going to provide us with some really great informative responses so that we can be better informed and just move forward and have better landlord-tenant transactions. And it's going to be really great. Really excited to bring you this information tonight. Excited to have Tori here. Thank you for joining us. Let's go ahead and jump right in. So first slide that we have up, the first slide that you'll see is regarding the Anti-Eviction Act of New Jersey. So this is a really important piece of legislation. So what this is it's law. It's law in New Jersey that says, because New Jersey is probably, if not one of the most like tenant friendly states in the country. Very, very friendly to tenants. You have to have a specific reason for evicting somebody. So we talked about this I think we've talked about it in several topics. It's come up with rent increases. It's come up with our eviction only course. It's come up with familiarizing yourself with the law and knowing your rights. So this always seems to come back. It's always one of the central points to landlord-tenant law, and I think it's where everything kind of ripples out from. Is this Anti-Eviction Act? So the Anti-Eviction Act basically says that the landlord has to have what's called just or good cause to evict you. So they list in this act, this like legislation, this written act from the state. It says you have to have certain reasons to evict someone. Can't just be because your lease ends. So that's what we wrote here on this slide, or what Dawn wrote on the slide. So thank you, Dawn, for more lovely slides. We really appreciate them. They're excellent. Certainly helps with the visual element. And I'm glad you can see them tonight. So thank goodness Tori's here to help with that element of it. So thank you. So basically it says, so you cannot be evicted just because your lease ends, because we're talking about breaking your lease. Now just because it ends doesn't mean that's grounds for evicted. So grounds for eviction per the Anti-Eviction Act are like, you don't pay your rent, or you're habitually late with the rent, or drug offenses on the property, or your behavior that's disturbing the enjoyment of the property by other tenants or your neighbors, lease term violations, health code violations, things like that. But they have to be specific reasons. So your lease ends, that's not a reason for eviction. Or the fact that your landlord doesn't want to start a new lease with you, that's not grounds for it. In those cases, when there is no new lease in place at the expiration of your current lease, you just roll over to what is typically month to month.
I was gonna ask, if you are on a yearly lease and your lease ends and it hasn't been renewed, does it go for the whole year, or does it go month to month?
So generally it rolls over to month.
Okay.
However, some leases will say, so the lease will say, you have to give me notice. The landlord will say, you have to give me 1 month's notice to renew the lease or to enter into a new lease. Or the assumption is that you're going to move out by this date, right? Or it will say that it will automatically renew unless you say that you no longer want to be in this lease. It can renew to a new yearly term. But in most cases, unless it specifies it in the lease itself, it's just going to go to month to month.
And the landlord, if they just don't want to, if they have no grounds or reasons to not lease to you anymore, they can't.
So they can't just like say, I don't feel like it.
So in that case, if your landlord is like, I don't feel like it, I don't want to do this, do you end up going to court or can you settle that outside court?
So it depends on the situation, right? And David will get into that more specifically,
Okay.
but in terms of like my general knowledge of it is that unless the landlord has grounds to evict you, like we said, per the Anti-Eviction
Mhm.
Act, like if you haven't been paying the rent or you pay the rent habitually late, and there's issues like that, they have grounds for eviction. Now, the landlord can propose new lease terms, right? So
Yeah.
they can say, okay, we're gonna enter into a new lease. So, but they have to give you notice of that as well. And these slides are gonna get into that. It's gonna say
Yeah.
the landlord has to give you a certain amount of time to let you know, hey, a new lease is coming
Mhm.
and I want you to sign it. Now, those new terms, like let's say if there's a rent increase, unless the town that you live in controls the rent, how much rent can go up, the rent has to be what's called reasonable. And if it's not, you can choose not to sign that new lease, or you can
Mhm.
choose not to pay that rent increase. But the landlord's remedy, if you don't do that, they can then sue you for not adhering to the new lease terms or for not signing the new lease or not paying the rent increase. And then it will be up to the judge in court to determine whether those terms were reasonable, whether you had notice and things like that. So
And that's what you talked about in the rent increases.
exactly. So Sarah
It's
talked
on
about that.
YouTube if you
Exactly. So excellent plug. So that's available on YouTube as well. So and hopefully David can give some more in-depth response to that. That can maybe lay out some scenarios, or he can talk about his experience with that. So hopefully he'll be joining us shortly. Next is what we're going to cover tonight. So we're going to talk about how to end a lease so that you can move out when the lease period is up. What happens if you need to move before your lease ends? And then when does the law allow tenants to legally break a lease? So it's actually where, I know, and again, for those of you folks who are not, regularly involved in the law, if you're not a legal practitioner or somebody who's in and out of the courts regularly or has been studying this, ahead of a presentation, it seems rather complex on the surface. It seems like there's a lot of moving parts, but we're going to break it down very simply for you tonight. Again, we're brushing with broad strokes. So for those of you who have, specific questions or instances or need advice, we're always going to refer you to legal services. They are the legal experts that can help you in that regard. But again, we're going to kind of break it down and make it a rather simple presentation for you tonight. We're just going to talk about those three simple topics. So again, how to end a lease so that you can move when the lease period is up, what happens if you need to move before the lease period ends, and then when does the law allow you to actually legally break your lease. So we can go ahead and move to the next slide. Thank you, Tori. You're doing a great job tonight. Excellent, excellent job. Super impressed. Super impressed. Oh man. Oh man. All right. So let's go ahead and begin. So notice to end a lease. So unless the lease says otherwise, notify your landlord in writing at least one full month before the end of your lease. So unless you or the landlord end your lease, all yearly leases and month-to-month leases automatically renew themselves. The only exception to this is if you live in a building with 2 or 3 apartments and the landlord lives in one of those apartments. So there's a lot, like in a lot of our classes in housing discrimination as well. The exception seems to be like is if the landlord lives on the property themselves. If it's like a 1 or 2 unit home and the landlord lives there, a lot of these things are not necessarily applicable. But in all other instances, if you have a lease, again, notice is required, to let the landlord know that it is going to be terminated or that you don't intend on renewing the lease. So the landlord must do the same in order to present a new lease with a rent increase or different lease options. So if you do not sign the new lease presented, you basically put the landlord on notice that you do not intend to move, that you intend to move out. So I just want to touch on that really briefly. So if this written notice is not given or is not given in the required time, when the lease will renew itself automatically, at least on a month-to-month basis. So that's kind of answering your question before. So basically what this slide is letting you know is what we just kind of had a little conversation about. Is that, go ahead, Tori.
Question really quickly. It has to be in writing, like a verbal contract is not.
Yeah. So written notice. So it looks like David is going to be joining us now.
You can just join.
So he just comes in?
I think so.
Okay, so, all right, let me just let him know.
I think he just accepts the name and just like joins.
I said that I think he just accept or join via the link and he should come in. There we go. Here he is. All right, lovely.
Let's see if he can hear us.
Hey, David, can you hear us okay?
I can hear you okay, yeah.
I can hear him.
Well, we might have to take that.
Oh. Let me try to see.
Oh, no, he
His camera is on.
Oh, no. Let's
There you go.
Camera's on.
Hey,
Can you hear us? Okay?
How are you?
David, you can hear us?
I can hear you. I can hear you fine. Can you hear me?
Sure, I can hear you very well. All right.
Good. Glad to hear it.
I don't think I need this mic
No,
anymore,
okay, that's
so you can
fine.
turn that off. Great. So for everyone who's going to go ahead had the chance to view this video, David, thank you so much for joining us this evening. David
You're welcome.
is one of my professional, colleagues from landlord-tenant court. We see each other often, if not exclusively, in Morris County Superior Court in the landlord-tenant court there. In my capacity as a resource navigator, so I come from Family Promise of Sussex County, which is a nonprofit organization that helps with housing crises. And we basically, the grant that we have, the CEDD grant, it stands for Comprehensive Eviction, Defense, and Diversion. And what that is it's a grant from a state entity like the DCA. They give us a generous amount of money to go to court and to help people who are at risk of homelessness. So that's the point of the grant, is that we are supposed to help people who are at risk of losing their home, and we're diverting or preventing eviction. And most commonly we see is non-payment of rent cases. So the idea is if, hey, you fell behind with your rent, we're going to help pay the rent. So that's basically how that works. And that's how I've met David. So David is an attorney from Legal Services of Northwest Jersey out of their Morris County office. He and his staff do an excellent job. And we work a lot together in tandem where he does the legal advocacy and they do some really, really incredible work there. And then we will combine forces together where they will work with a client in the legal regard and they'll talk to the judge, to plaintiff's counsel and the landlord, and they'll say, okay, can we get this adjourned? Are there any procedural or constitutional deficiencies where we can get this dismissed? If not, how can we negotiate? Can we settle? Can Family Promise come in and help pay some of the money? And it's been a really great collaborative effort. And it allowed us to continue that relationship and have David come and speak to our class. And David, again, thank you so much for dedicating your evening a portion of your evening to this class. This is my colleague, Tori Young. She's our marketing and fundraising coordinator. She's our
development coordinator, also media personnel.
Exactly. So, and she's here tonight to help with the tech elements of it as well. So thank you so much for joining us. And David, if you want to give us a little bit of your background, how long you've been practicing law, what brought you to legal services, what brought you to landlord-tenant law, that'd be great.
Sure, great, thank you. So my name is David Saltzman. I'm an attorney. I work at Legal Services of Northwest Jersey, and as Frank mentioned, in our Morristown office. We have Legal Services of Northwest Jersey covers the 5 counties that are the northwest corner of the state of New Jersey. In all 5 of those counties, we have at least 2 attorneys that will attend tenancy court whenever sessions are held in the tenancy court. I am the housing team leader, which means I'm, the senior attorney amongst all of our housing attorneys. And so therefore I'm able to, part of my assignments are to not just represent clients in tenancy court, but also to provide advice to younger attorneys as they come in, to get them all trained up as they just enter our office. And sometimes we talk to folks and just provide advice, because sometimes representation is unnecessary, but advice is really, really helpful. And so I do all those things for tenants in the northwest part of the state. I attend court in all 5 counties, although mostly I go to tenancy court every Thursday in Morristown. And I'm really just happy to be here. My experience, I've been an attorney, it's just about 24 years since I was admitted. I've been practicing those 24 years. The first 8 I did in private practice, but since that time, I have been attending worked for legal services in Northwest Jersey.
Oh, wow.
So I've been able to assist many, many folks. And why tenancy? I guess the simple answer is when I first started doing this work, I was doing foreclosure work. And I sort of got bit by the bug, because when I was doing foreclosure work, foreclosure defense, when I was doing that work, I was really trying to keep people in their houses they owned. When I started, the further along I got, they asked me to begin to do some tenancy cases, because some of the concepts are similar. And so tenancy just seemed to make more sense. And I felt like as a professional, I could do more good for an individual in the tenancy court over the period of an hour or a couple hours. But in foreclosure work, that would take me days and weeks and months. And so I really felt like I could get the most cosmic bang for my buck in helping people in the tenancy court versus, doing foreclosure work.
Gotcha.
And so that's why tenancy. And so the good news is for me although I've done other things in legal services, I get to do 100% of my time is dedicated to do tenancy work.
That's excellent. That's excellent. So are you saying, and just as a quick aside, because I think Sarah Webb, who is an attorney who joined us for a prior session from Community Health Law Project, she had given a presentation not too long ago at the DCA and had talked about what the purpose of special civil part is, and why landlord-tenant matters are heard in the special civil part of the Superior Court. Are you saying, like, when you say that you get to help more people in landlord-tenant court in a shorter amount of time, like your cosmic bang for your buck, are you saying that in the foreclosure area of it, is it just like a longer drawn out discovery process? Is it not like a summary proceeding?
Yes, exactly correct. So landlord-tenant court is a summary dispossessed court. And what that means is, right, those are fancy lawyer words, but what that means is landlord's trying to put you out. All you have to do is show up in court on the day of, right? That's where you provide your defenses. But if you don't appear, the court will dispose of your case. They'll enter what's called a default against you. In the foreclosure part, that just took a lot longer, and the odds were a bit longer that you were going to be able to save somebody's apartment or house or a condo or a townhouse or whatever. And so the success after having done foreclosure work for a couple of years and not having a great deal of success, mostly in part because when folks were in foreclosure, every month that goes by, the numbers are that much larger, right? For mortgages might be $3,000, where your rent might be $1,800. And the numbers were just that much larger. And it was just it was difficult to come back from that. And so in tenancy, I felt really that I could have just more success faster. And so I felt like I could help more people. And that was what I wanted to do.
Yeah. Well, they're so lucky to have you and have your legal acumen and experience and expertise, because from what I've, observed and perceived, you and your team are really just doing some amazing work down there. And again, I wanted to express my gratitude and just how grateful I am to collaborate with you guys professionally. So it's been a wonderful experience. And again, thank you for your time this evening.
No, you're welcome. If I can just pat my team on the back just for a second, right? There are 5 different legal services offices around the state of New Jersey. We're the only one where people can walk up to us at the time of court and expect to get representation. right?
Wow.
We come to court with attorneys who don't have cases. And so their acumen and their legal skill, right, really comes into play when people approach us. We don't know what we're getting involved with when folks approach us. And we do our very best to, sort them out and do it rather quickly. And so the bragging part is over.
Well, no, that's really great because as you know, in part of this series that I've been discussing this being the sixth course in that series, one of the through lines that I always try to communicate is get in early with legal services as soon as possible before get in when you're starting to struggle with your rent before you get served with a summons and complaint. Because I do say that your constitutional right to counsel isn't guaranteed like it is in criminal court. But it sounds like, at least in the Morris County capacity, that they could have some luck, at their day in court, because in some other counties, it could be difficult when people are running up to an attorney the day of and saying, I've got to go into mediation right now. Like, what do you think? That
Correct.
must be yeah.
So the good news is we're really, especially in our Morris and our Somerset County offices, right, our two largest offices, we're set up. We have intake folks who come with us. We have Spanish speakers who also do intakes for us, meaning we're all set up to receive people as they walk up. But you're right, in bringing up your through line of getting counsel and doing it early, I think it's important to note that the earlier we have 5 offices, only 2 of those offices take walk-ups. The other 3, you sort of have to get in the door before you get to court because we're just not set up to do that.
Right.
In some of the smaller counties, Sussex, Warren, Hunterdon specifically. And so the point is that, the earlier you can get to us, the better chance you're going to have of a positive result.
Excellent.
Awesome.
Well, that's wonderful. Thank you for that. So
you're
what we've been talking about before you were able to join us, and we actually didn't get too in depth with anything before you were able to jump on the call. What we've been communicating so far, and we just kind of jumped into the very basics of it at this point. So one of the questions that Tori had brought up that I started to discuss, but I thought you might be able to expand on a little bit better, David, was in all instances. So one of the things that I think we're kind of not necessarily confused about, but we just needed some explanation of, is that when somebody when you don't when notice isn't provided to terminate a lease, and that lease then rolls over, is it automatically month to month, or
Yes.
all right, well, in what instances will it renew into another yearly lease term? Does it have to specify that in the lease itself?
I think it would only, yes. I've seen leases where they say if nothing happens, that it automatically rolls over into a year-over-year lease. But generally speaking, if you have a 1-year lease, a vanilla lease, on a form, right, that doesn't specify, your lease automatically at the end of the term by operation of law, and those are fancy lawyer words, that just means all by itself, right? All by itself, it just rolls over into a month-to-month lease.
Okay, that's good to know. And what about the notice itself? Does that have to be written? And what I mean is to break it down on both sides. So let's say if the landlord intends on, he wants the tenant to sign a new lease and maybe introduce some new terms or raise the rent, does he or she need to provide that notice written? And what kind of time frame are we working with in that regard?
So I'm going to throw several numbers at you, and I hope not to be confusing, right?
Yes.
I'll approach this first from the tenant side, and then I'll approach it from the landlord side.
Great.
Right? So if a tenant if they want to continue with the lease, they should let the landlord know. Your slide here indicates, unless the lease says otherwise, notify your landlord at least 1 full month. I would submit that it depends what the lease says. 1 full month, I think, is a good rule of thumb. Some leases that I've seen in the past require 60 days or 2 full months before the end of your lease to notify the landlord of your termination.
Okay.
So check with the language within the lease. If the tenant wants to terminate, again, just at the end of the lease term, because it's time for them to move on, they want to find another place, maybe they're going to buy a house, I would just give more time than less, right? That should be sort of a rule of thumb.
Right.
But again, review the lease terms.
Right.
From a landlord's perspective, there usually what happens is, one, the landlord may just simply want to renew the lease and give you the same lease with just new dates. There's nothing wrong with that. That's fine if that's what you choose to do. Frequently, what the landlord will do is, over time, landlords tend to want to make some changes over time. They want to increase rent and add additional things. A big trend that I've seen over the past couple of few years are landlords adding additional fees, meaning water fees, sewer fees, electricity fees for common spaces and things like that.
Mhm.
And so if there are changes within the lease, the landlord, there's no real specific time, but I would suggest something like 30 days in advance at the end of the lease, they'd have to give you that revised lease. Now, more specifically, if the landlord is just changing the lease in order to increase the rent, right? Many times what a landlord will do is they'll give you a full complete lease, maybe 10, 12, 15 pages for the first year. And then annually, what they'll do is they'll renew the lease terms with some small changes and do it just on one sheet of paper, which is fine. There's nothing wrong with that. But when a landlord wants to increase the rent, they can do it by just giving you a new lease. And that's sort of the old-fashioned way. Nothing wrong with that. If you agree to it, then you can sign it. However, if the landlord gives you a rent increase, they're really supposed to, in accordance with the case law, give you a very specific notice. The case is Harry's Village versus Egg Harbor Township, but that's less important. Landlord needs to give you a notice that does two things within the notice, right? One, it's a notice to quit. It's always a notice to quit. And it's called, the first paragraph says, your lease is hereby terminated, right? They can add more language. They can make it fancy, but that's what it's got to say. And the second paragraph has to say, and by the way, we're offering you a new lease at this increased amount, right? They have to do it. They have to at least give you 30 days in advance. And I would suggest that that rent increase, in accordance with the case law-ish, it has to be below 10%, right? I would
Okay.
submit, and every legal services attorney who does tenancy across the state of New Jersey would tell you that if a landlord increases rent more than 10%, that is an unconscionable rent increase. And we can discuss that maybe at a later date. But if they're going to do that rent increase, technically they should do it with that type of notice. Two things: termination of lease, offering a new lease.
Gotcha.
So I think I approached it in both ways. Yeah.
Yeah, absolutely, and that's excellent. And really such great information. And when you had mentioned that term unconscionable, that is actually something we covered in our past class with regard to rent increases. And I know that unconscionability is kind of this. It sounds like it's not really defined by the courts based on like what I've seen. It sounds like I've heard this shocks the conscience of a reasonable person like analysis. I've heard all kinds of different views. What's your spin on it in terms of when you see, let's say, an example of a rent increase, when you look at it, I know you use 10% as that number, but anything beyond that, like let's say if it's not a rent controlled, town, like when you look at something and you say this is unconscionable, like what kind of factors are you typically looking at, like numbers specifically?
That's it. No, that's an excellent question. So let me just ask this question before I answer, and I'll tell you how candid I'm going to be. Will landlords be seeing this?
Probably, yeah.
Maybe, possibly.
Yeah,
Okay.
I would say this is more
So
tenant focused, but landlords will likely see it and can benefit from it.
fine. And so when a rent increase, that unconscionable number, right, is one that we largely infer because all of us agree around the state that 10% is the magic number. The statute doesn't exactly rightly say that, right? So shocks the conscience, right, is as sort of the offhand definition for unconscionability. I think that's a pretty good one. There are certain characteristics though that we look at, right? Because I have seen before where rent increases are in fact more than 10%, but there's some characteristics that sort of give me pause to sort of look at it in a longer term capacity. Let me explain. For argument's sake, a tenant's been living someplace for 15 years, and the rent was $1,000 when they first moved in. And for the past 15 years, the landlord hasn't increased the rent once, not once. And in theory, they can increase it 10% every single year. And so if sometimes there's a big jump in the rent increase and it might initially appear to be unconscionable, but then thereafter you look at it and say, well, they really haven't increased the rent ever since you've been there. And so is it a reasonable number? Can you do it? And then we sort of do that type of analysis with the client. Now, no client ever likes to have the rent increased, right? Because no one wants to pay more for the same stuff. But the reality is that right. But the reality is that a landlord is entitled to increase it. Now, if we claim that it's unconscionable, we can request a hearing on the conscionability, although that's not a word, but the conscionability of the rent increase. And in response, the landlord could and would have to sort of prove out sort of, well, here's all my fixed costs that have increased. Right? Here's my taxes have gone up by 3%. Here's my old bill. Here's my new bill. My, the natural gas has increased if that's how they heat the place. Natural gas or heating oil has increased by this. This cost has gone up. And so there are times, even when it exceeds 10%, that a landlord can get in front of a judge and prove that this was necessary. And I'll give a specific example. Some towns, my town a couple of years ago, they went through and they sort of did a reassessment of the valuations of the homes, right? And therefore increased taxes. So year over year, taxes almost always go up, but we had kind of a big bump all at once and all in 1 year. And so there are some times where things like that happen where, to be fair to landlords, that they can sort of prove to the court that, hey, my costs went up, so therefore I need to increase, and it's beyond the 10%. They might prove that out to the judge, and the judge might be satisfied with that and permit that rent increase. So just because I think it's unconscionable and I pound my little fist on the table doesn't make it so.
Right. Oh, okay. Okay. And again, that's super helpful because I think and one of the things I was explaining to our audience and viewers of this material is that I think a lot of this stuff can be seemingly, some of it seems pretty simple, right? Or I do say we're going to break it down in a very simple way for you, but even if it seems simple, like, hey, here's what you can do, here's what you can't do. I know they can be very complex matters, especially like you said, and that's why lawyers are hired and they're in place is to help break down this what is seemingly kind of convoluted subject matter. And to be even something like a rent increase where you have to separate it and say, okay, was there notice? Did the notice say the lease is ending and you're starting a new lease? Was the notice given in a proper amount of time? Was it considered conscionable? If it's unconscionable, why is it unconscionable? And here's all the factors that we have to analyze through a hearing with all of this. And then there's procedural elements on top of that in terms of filing the paperwork, having a hearing, bringing your evidence, cross-examining witnesses. It's a lot, and again, just really just your thorough, in-depth answer is really just a great example of why we're so appreciative to have you as a guest, because it really allows our audience to understand these nuances in the law, because it really is seemingly it can be complicated. So thank you for expanding on that with us, David. Appreciate that.
No, you're welcome. I hope I sometimes, if you need to hustle me along, I get it. Sometimes I talk too much.
No, you're preaching the choir. I really appreciate that, and I think honestly, it's really only serves to better educate our audience to give them that in-depth analysis. But moving forward, we want to talk about moving out before the lease ends. So that's kind of like the next topic that I wanted to discuss with you. So, with regard to, because I think we talked about notice and how you talked about a general rule of thumb and what's accepted amongst practitioners as the proper amount of notice, or a good rule of thumb, that being 30 days. Some leases insisting upon more time in terms of the length of notice. But in ending your lease, so let's say from the tenant's perspective, in terms of wanting to end a lease, what would you recommend is a good way to go about it? Would you, and just from your experience, because we have some general stuff, in terms of moving out before your lease ends. So to our audience, if as you're looking at this slide right here, we'll just kind of briefly touch on the bullet points, and then David, I'll pivot back to you. So here it says, if there is no legal reason for breaking the lease, but you need to move, that being, or ergo a new job, a divorce, moving to care for a loved one, a landlord cannot stop you from doing so, but can sue you for time the unit remains unrented. So I kind of want to unpack that statement right there. So first of all, let's back it up and say, in parentheses, we have new job, divorce, moving to care for a loved one. Are these these are what are considered like are these not legally recognized reasons for breaking a lease, David?
Well, I think they're from a human perspective, I think they're real reasons why real people would want to break a lease. But I think they're not legally sufficient to provide a defense. There's,
Okay.
if I may, there's case law specifically on this issue, old case law, Summers versus Crydell, and in that specific case, right, it was all about the landlord being able to sue on the balance of the lease for whatever rent was entitled to them, right, and the simplest answer is a landlord is entitled to do that, and so there aren't many good ways to terminate a lease. And so my best advice, right, is give as much notice as you can, smile really nicely, and bring over a cake or pie when you do it.
I think that definitely will help draw the sting for sure. The the next, but the next part of this sentence also says, so although there's no legal, these reasons aren't legally recognized or defensible, I guess we should better say. Um, what does it mean when they say they can sue you for the time the unit remains unrented? So are they saying that? Does that mean that it can be for as long as it remains unrented, or does that mean until the expiration of the original lease that was broken?
So the simple answer is the expiration of the lease,
Okay, I got you.
right?
So, okay,
And so I mean, certainly that's why I was jokingly saying you bring a pie, right? Because you want to minimize that as much as possible. I've seen people who just go up to the landlord. I've given this advice more than a few times. Go talk to the landlord, tell them what's going on. Say I got a new job. I got to go to London. I'm really sorry. I don't want to break the lease. Now, we probably get into it a little bit, but some leases provide for a time frame if you have to terminate early. Other leases provide for other mechanisms to sort of get out early.
gotcha, gotcha. And then some advice here that's bulleted kind of as like sub or nested points here is give your landlord written notice as soon as you know the date you will be leaving prior to the end of the lease date. So as you had mentioned, David, the earlier, the sooner you can let them know, the better. And then when that date arrives, remove all your property, turn in the keys promptly. And then I believe a lot of these points are extracted from the Legal Services of New Jersey landlord-tenant manual, or the landlord-tenant rights booklet, that is really helpful and has been a roadmap for this particular series. And it says, I think, as advice, to ask for a receipt or to take a friend to witness the surrender, to protect you from any erroneous information that or claims to the contrary, that you didn't turn in your keys on a certain date. So I guess basically to make sure you are dotting all your I's and crossing all your T's and having documentation of when that ended, so that if anything is claimed in terms of money that you might owe, that the proper dates, and if you should have to end up in court because of it, you have everything, or as best as you can, to have your ducks in a row to put on a case. Do you think that's sound advice, David?
I do. I think there's a couple of different points I want to add to that as well, right?
Okay.
Again, the case law says the landlord can sue you for whatever the balance of the rent is due on the end of the lease. However, the landlord does have a responsibility to mitigate their damages, right? Which means very specifically, and mitigate here just means they have to minimize, they have to do all the things that they can do to relet the premises to any other person. And so the better shape and condition you leave the apartment as you walk out the door, the easier it will be for the landlord to relet the place. So if they sue you for the back rent that you left on the lease, in theory that will be mitigated, that will be minimized, because someone moved in. If you had 6 months left, someone moved in 3 months out of those 6 months, and now they can only sue you for the 3 months, right? So that's really, really an important thing.
Gotcha.
another issue which I've seen before is, right, you still have if you've given a security deposit, you still have a security deposit that's outstanding. And so it's important to take a friend to witness to turn over the keys, great. But I would get a video camera or your little iPhone, right? And I would take pictures, right? Take pictures, show the condition of the place, right? Because under it's not the time for this, but under the Rent Security Deposit Act, right, the landlord is required to give you your security deposit back in 30 days from the time of your actual departure, whatever date that was. And if landlords sometimes are less than honest, and they'll come along and they say, well, we had to respackle and paint the place, and that here's your security deposit minus $1,000, right? You can take pictures and you can show here's what the place looked like. It didn't need to be repainted, or maybe it did, I don't know, right? But you can show the condition of the premises. The landlord alleges that you broke all the windows and you ruined the hardwood floors. You can have pictures of those things. So if you ever needed to sue to get that security deposit back, you would have that as proof, like really what lawyers call prima facie proof, primary proof that you could demonstrate, here's what the floor in fact looked like, here's what the windows in fact look like, and they weren't broken. The landlord's required to give you that security deposit back in 30 days. If not, a tenant can sue the landlord. And if a court determines that there was any rent security deposit that was unlawfully withheld, a tenant can get back double damages, meaning double the amount unlawfully withheld. So that's a big deal.
Wow, absolutely. Okay, that's good to know. It's crucial to know. So, all right, excellent. So, and I think you touched on that because that is bulleted in there. And just going back to your point about your example about how the landlord, you moved out and 6 months was left on your lease, but he or she was able to rent it out within 3 months. They no longer can sue you for those remaining 3 months left on the original lease. But in the event that, let's say, the landlord ends up suing you for the remaining lease, and they never end up re-renting the unit, for those 6 months. We'll use that 6 months as the example, and they sue you for that full 6 months. What kind of burden of proof do they have in the courts that they have when they do sue you for that back rent, or that money, not back rent, but that money that was owed that you broke the lease for? What do they have to show in court? Like, do they have to show that they've made an effort to re-rent it and so forth? And what's the extent of that proof?
Sure. And in the Summers v. Credell case, that was actually really certainly the essence of what was going on. The landlord had to demonstrate what they had done. And this is, I don't know, 50 years ago, right? So that they had posted the apartment in the paper, right? That they had inquired with rental agencies, if such things still exist. I don't know that they do, right? But that they had done some things to try to mitigate their damages. And so
that's what you're saying.
So if there's there's lots of tips I can give here and there, but right, if you are the tenant and you're vacating early, right, two things I would invite you to do, right? One, quickly make a friend with one of your nearest neighbors, and two, get their phone number, right? Because if you haven't made friends, you will make friends, because you want to be able to call up neighbor to the left and say, hey, neighbor to the left, right? Was that apartment relet? And if so, what month did they move in? Right? Because sometimes a landlord will attempt to withhold that information. Oh, I don't remember, right? But if you can get neighbor to the left to say, hey, that they left, I'm sorry, new people came in there as of April 1st, so your damages are likely mitigated. And if you could get, neighbor to the left to come in and provide testimony in court, that'd be even better.
Okay, that's excellent. That is super smart. That's great advice. All right, thank you, David. So we'll go ahead and move on to the next topic, or we'll just continue moving with our slide. So one thing before we proceed with this particular slide, the legal reasons for breaking a lease. One thing I wanted to just back up to, and it's nothing that I think was listed in the LSNJ manual or anything that's going to be featured on these slides, but it's something that popped in my mind while we've been talking about that, is the concept, if you have time for it, David, is the concept of liquidated damages. And speaking from my own personal experience, there was a situation in my own experience where I did have to terminate a lease early. There was some personal reasons why I needed to vacate an apartment, and this apartment complex was trying to sue me for what's called liquidated damages. And I had hired an attorney, and the attorney had mentioned something about, well, the reason why they can't use liquidated damages is because I forget exactly what the reasons was. It was like it was some kind of they were using it as a reason for some kind of cost or something like that. But for whatever reason, they weren't able to assert liquidated damages. But could you maybe, if you're able to, I know it's not really necessarily in the subject matter that we were prepared to discuss tonight, but if you have any knowledge on liquidated damages, what exactly is that? And
Sure.
when can an apartment complex or a landlord assert liquidated damages against a tenant who breaks a lease early?
I think when we talk about liquidated damages as it relates to a tenancy action, right? I really think what we're talking about here is your security deposit, right?
Gotcha.
Generally speaking, right? Liquidated damages is when, I'm going to explain it in, I think, a very layman's type way, that we acknowledge that at some point in the future we may have differences as to calculation of funds due, and we're going to agree that whatever the difference is, that a certain specific amount is going to be the liquidated damage, right? And what that means is it's just the amount that we're all going to say, that's fine, that's the amount, right? And so when we talk about this, we're talking almost exclusively about a security deposit here in the state of New Jersey. And to be more specific, when we're talking about a security deposit, there's a law here under the Rent Security Deposit Act here in New Jersey. Rent security deposit can only be 1.5 months in a residential context. Commercial, it can be much higher, right? And so sometimes when there's a dispute, it's easier to say the liquidated damages are what the security deposit is, that 1.5 months. Now, sometimes folks fight it out, and other times folks do not fight it out.
Hmm.
And so that becomes somewhat of a difficult thing.
Okay. Okay. Very good. Thank you. I appreciate you for
You're welcome.
indulging me for that for a moment. Because
No.
it just was something that popped in my head, and I was wondering if, and I appreciate you expanding on that. So, moving along with the curriculum for this evening, let's go ahead and talk about the legal reasons for breaking a lease. So, just to kind of recap to our audience and future viewers of this particular video, what we've talked about so far and walked through is, basically when a lease ends, and just simply the fact that a lease ends that's not grounds for eviction. We touched on the Anti-Eviction Act and that there are specific reasons for why you are being evicted. Just the fact that your landlord doesn't want to go into a new lease with you is not grounds for eviction. If there is no notice that a new lease is, going to be started, then it simply rolls over to month as a general rule of thumb. That in order for you to leave, if you want to break your lease, or if you intend on staying, or not renewing your lease, then you need to give notice. Usually 30 days is the general rule there. But David, what if somebody, you might have touched on this, but if you could reiterate as we kind of just do a quick recap, what if somebody says, hey, I gave you notice, landlord, that I would needed to leave, and I gave it to you within 30 days of leaving, or let's say like the lease was set to end on June 30th, and by June 1st, the tenant put the landlord on notice and said, I do not intend on renewing my lease on June 30th or after June 30th, and I'm going to be out.
Right.
I found a new job, and I'm moving on. And then let's say that
Right.
job opportunity fell through, and
Mhm.
this tenant needed to now stay, or they decided to stay. Does the landlord have recourse there? Can they say, nope, too bad, you already said you're out on the 30th, and I have prospective people coming in to look at the place already, and no, you can no longer do that, and you're gonna have to leave. Is that something they can do?
So landlord, it depends. I think what I want to say is, from a practical perspective, not even sort of looking at what the law says, but from a practical perspective, if the landlord has already acquired somebody else, and if they've signed a new lease and accepted money on that, that's where it becomes that much more difficult.
Gotcha.
Frequently, if a landlord has not accepted new money, has not found a new place, they'll be glad to keep you, right? Because a landlord's sole reason to be in this world is to generate rent money on a monthly basis, right? That's all they care about. And
Mhm.
so as long as you follow those rules, you should be fine. So you don't have to, the simplest answer is you don't have to move out just because you gave the notice, right? That's the sort of the tenant protection methodology. And under the Anti-Eviction Act, right, no landlord can evict a tenant and up to and until they've proven a case in front of a judge and there's an order signed by a judge who wears a real live black robe. And so you don't have to leave, but certainly you might be putting a landlord in a real bind. And so just know that things aren't going to get easier from there if they've already found somebody else.
Gotcha.
So technically, that's not a reason for the landlord to evict you, but life gets harder if that
Gotcha.
happens.
Okay. All right. Very good. All right. So now let's go ahead and move forward, everybody. We're going to move to the because I think we've kind of really and thanks to you, David, for allowing us to give us this thorough, recitation of some really great examples, a really great, just rundown of the applicable law, and some just really excellent, thorough, considerate, and thoughtful, expanded answers on that. So that's great and appreciate that. So now as we move forward, folks, for those of you who are tuned in watching us or those of you who are watching the edited recording of this, we are now on to legal reasons for breaking a lease. So per the slides, what we have here is that we have what is called constructive eviction, or I think that kind of ties into habitability. So legal reasons for breaking a lease. So if your landlord refuses to make necessary repairs to very bad conditions that make housing unsafe or indecent, and in parentheses, it's listed as constructive eviction. So I guess leaving or withholding rent and vacating the property because of the failure to make those repairs or make the home habitable. I guess that is called constructive eviction. But David, you can expand on that for us. I know Randy certainly did when Dawn had hosted this course last week, and they went into habitability, which I know we could spend hours on just talking about that. The other point is death or illness of a tenant or a tenant's spouse, and then a tenant is a victim of domestic violence. So we'll go ahead and talk about that first topic. The landlord refuses to make repairs. So if you could, talk about constructive eviction, or just kind of like what it is in theories, if you could explain to our audience for those, because I have to say, in my own experience, as and just the reason, and we'll actually just something popped in my head, but we'll circle back to that momentarily. But let's stay on the course. That's my ADHD brain. But with constructive eviction, what I do see in my experience, and again, I'm not a lawyer, I'm a social worker, and what I see in court, in my experience, in engaging with you guys and collaborating with legal services, and the interactions I've had with clients, is that they typically will assert or some kind of habitability defense, or they'll say, "Oh, I withheld rent because the landlord failed to make repairs," and it's usually in response to an eviction lawsuit that was instituted or initiated by the landlord for non-payment of rent, and the tenant is then saying, "Oh, well, I never paid rent because the place is uninhabitable, either because of mold or there were other repairs that left the place unlivable or unsafe or indecent." And my understanding, or at least what I've seen, is that they typically have not raised that defense properly or in accordance with the applicable, New Jersey law as it pertains to habitability and Marini defenses and bonds and hearings and so forth. So could you kind of just, and again, painting with broad strokes, walk us through from when a tenant experiences some disrepair in the home, from putting the landlord on notice, from putting money in escrow, to any kind of remedy the landlord might have it for recovering that back rent, and how it proceeds from there.
Sure. So in talking about, first I'll just address constructive eviction because it's on the paper and it's point number one. Very specifically, a constructive eviction is really where the place is in such disrepair that no one could be expected to continue to live there, right? The conditions are so bad, right? The toilets don't work, right? It doesn't have any water or heat or other vital services. The power is out. The power was never on, right? It sounds ridiculous. I get it, but
Right.
right there's or specifically, maybe the place, it used to be a shoe store and now it's an apartment. It's not suitable for human habitation. It doesn't have the right things, right? The constructive eviction is an issue that can be raised by tenants to say, hey, landlord, you kept such poor maintenance of the place that you constructively evicted me by failing to, clean, fix the toilets, by failing to provide electricity or other vital services. And so therefore, because of this constructive eviction, I was effectively put out. And so therefore, you can sue me, you can try to see. The problem is that this almost never comes up in tenancy court, because in theory, constructive eviction is one of those theories that you tell a landlord you have already constructively evicted me past tense, and it usually is an affirmative defense to it's a defense to when the landlord tries to sue you for the balance of the rent.
Gotcha.
And so it's less appropriate in the tenancy court, although it appears in the treatise, right? It is less helpful there. But as it relates to the condition issues, right? Landlord is required to give you a place that is habitable and suitable for human habitation. What that means is it should have basic services: heat, hot water, cold water, and heat can come in several different ways: electricity, gas, natural gas. It can come via oil, however it happens, but it's got to have those things. And so when a landlord provides you a premises that are unsuitable for human habitation for whatever reason, right, a tenant has really the right to do one of two things, and these two things are accepted by the court. These are mechanisms that the court says, okay, we understand this. One, they can do what's called repair and deduct. Right, there's a broken window, you can repair the broken window, give the landlord notice in writing if you can. And then if he doesn't do anything to fix it, you can repair that window. And then when it's next time to pay the rent, you give the landlord the rent minus what it cost you to repair the window and give them a copy of the receipt. That's repair and deduct. Courts acknowledge that works, right? Or you could do what's called a rent strike, or you could withhold the rent, right? Now, both of these methods, right, require giving notice to the landlord, and more specifically, given written notice, right? Most folks go for the rent strike because that's more dramatic, and I get all the reasons why. And so what I want to suggest is you give the landlord more notice than less notice, right? Hey, landlord, here's all the things that are wrong. The lights don't work, the toilet's broken, the this, the that, all the windows are broken, right? If you don't fix this, I'm going to begin to withhold the rent. I would give 2 written notices. Send those notices in writing. Keep a copy of the letter that you sent to the landlord, right? Then once you figure it out, you've given them at least 2 notices. I would suggest 3, but at least 2 notices. Then the next time the rent is due, November 1st, that's the next time rent is due, you give the landlord the next letter dated November 1st. Dear landlord, I'm withholding the rent because you have not made these repairs. All the repairs need to be all the same from letter to letter, from text to text, or not text, but from message to message, right? Sure. List all the same reasons. And I would give that letter to the landlord each and every month when the rent comes due. Eventually, the landlord will find that they need to take you to landlord-tenant court because they're not getting paid the rent. And you would bring these letters. They're awesome when a tenant does it this way. You bring all these letters and say, Judge, right, I sent him these texts, I sent him these messages, I sent him emails. I got these 5 letters that I sent him. The first 2 before I started withholding, and then these 3 for the last 3 months that I was holding the rent, right? Judge, I've done all I can. I let him know what I was going to do. I'm withholding the rent, and I still have it. You must still have the rent. Then, and only then, the judge can give you what's called a Marini hearing, right? It's from the Supreme Court case Marini versus Ireland. This is the most amount of cases I've ever remembered in one session. So in Marini versus Ireland, the court can schedule a hearing for basically what's called a rent reduction. And the tenant would go and say, Judge, the toilet's been, there's also a case before called Berzito. But in the Marini case, the toilet, there was one toilet in a whole apartment and it was broken, not broken on top, like it was unclean or anything, but it was like the pipe was broken under the floors, right? Tenant couldn't do anything about it. And so the judge determined in that case, that was early 70s, that the place was like 100% unusable, because if you can't use the toilet, you can't live there, and therefore the court gave 100% abatement to that tenant.
Oh, wow.
When this happened, yeah, that candidly, that never happens, right? And so
Right.
that was the last time it happened, maybe. And so I've seen these cases happen. I've seen, and what you need to know is, in order to get this type of hearing, it's not just that you come to court and say, Judge, the place is a wreck. You got to say, Judge, the place is a wreck. Here's all those specific things. Here's all the notices I've given. And the court's going to demand that you deposit all of the rent money that's in dispute.
Okay.
So you would have to deposit all that disputed money. And the reality is if at your hearing, the judge doesn't think these things are important enough, the judge can just turn over all that money by order to the landlord. And then you've been withholding for nothing.
Wow.
So that's condition issues in a nutshell. I'll do the next two, I think, in a more summary fashion, right? Specifically, death or illness of a tenant or a tenant spouse, there's a statute that says it can be done, right? It can be done. And so you can notify, right? Because think about it this way, right? When older folks, right? If older folks are living on Social Security retirement, right? Two older folks, and they can make the rent with both of their Social Security payments, but one passes, there's the reasonable expectation that the surviving spouse may not be able to make that rent. And so there's a statute on point, which I can cite, but it basically allows the tenant to give appropriate notice to a landlord, but then be able to break the lease because they just can't afford it based upon their income. 2, tenant is a victim of domestic violence. This one is there's no magic in the law, but this issue is really kind of sort of like magic, right? If a victim of domestic violence lives in a place and the domestic violence frequently, not frequently, doesn't need to have occurred there, but if it had occurred there, it's even more compelling that they can breach a lease and get out rather quickly. I think my recollection is it's a month and a half or 46 days. They have to give notice and sometimes stay there for that time, but they can get out of that lease. And the most compelling reason for this is because you're literally your abuser, right? Frequently you lived with them, but you don't have to. But they know where you live, especially if you're a co-tenant there, right? They know where to find you in the future. And so this is a really compelling reason for the legislature to sort of get you out of this as soon as possible. So thank you, I appreciate that. So. Right. So this is death of a tenant. So valid 40 days after receipt. If the rent owed up to that point has been paid, good. Property is vacated at least 5 working days before the 40th day, and the lease does not prohibit early termination upon death.
Okay.
So that's some good news. Yep.
And then and then we also did we wanted to touch on not in addition to death, also illness as well. So and per the LSNJ manual, it says that any lease for 1 or more years may be ended before it expires if the tenant or the tenant's spouse becomes disabled due to an illness or accident. In such cases, the tenant or spouse must notify the landlord with the following documentation: 1, certification of a treating doctor that the tenant or spouse is unable to continue work; 2, proof of loss of income; and 3, proof that any pension, insurance, or other assistance to which the tenant or spouse is entitled is not enough to pay the rent, even when added with other income. And I think it's the same too, that the termination becomes effective 40 days after the landlord receives the written notice. The property must also be vacated and possession returned to the landlord at least 5 days before the 40th day. So,
and if you can help yourself, make sure that you leave it in broom clean condition, right? Leave the place better than you found it.
Excellent. Excellent. Appreciate that, David. Thank you for running through that with us. I appreciate that. We
You're
also
welcome.
had a quick point with regard to, and I'll read it for our audience as well. So, and again, just as a quick recap for everybody who's joined us, and for anybody who happens to view this material at a later time. Again, you can't be evicted just because your lease ends. Notice to enter into a new lease needs to be given as a general rule at least 30 days. Written notice, and then that applies to changes for the new lease, things like that. You cannot be evicted again just because, and that's I think a really important point that I wanted to discuss with our audience, that you cannot be evicted just simply because your lease ends. Per what you've been saying, David, it sounds like that you have to have your day in court. Your landlord has to establish just or good cause, and that, in order to, if you want to break your lease, that you can do so, and there are non-legal reasons for doing so, but you can possibly be expected to end up paying the difference between when you broke it and when your lease ends. But if your landlord wants to recoup that money, they have to show that they tried to mitigate or minimize those damages by re-renting the apartment. Um, and then there are, of course, we just talked about some of the legal reasons. So again, can't be evicted just because your lease ends. And then we talked about rent increases, rent reasonableness, changes in the lease, and that it requires notice and reasonableness and things like that. So that was really informative. Again, you can break your lease, but landlord can recoup those funds, but you have to have they have to mitigate those damages. And then, of course, there are the legal reasons. So we talked about constructive eviction as a result of inhabitable living environments. We talked about death and illness of a tenant or a tenant's, or death of a tenant or a tenant's spouse, so death or illness of a tenant. And then, of course, we talked about now we've come to senior tenants needing to live elsewhere. So this seems to be a very nuanced or very like specific. It was a very short part of this chapter in the manual, but just wanted to touch on it just very briefly. Just run down these bullet points. And so tenants over the age of 62 can break their lease if they have to move into a nursing home, assisted living facility, or continuing care retirement community. Written notice must be given that contains a statement for the tenants from the state, excuse me, that's a typo, from the tenant's physician stating tenant needs the services provided and proof that the tenant has been accepted into the facility. And then tenants over the age of 62 who are not living in low or moderate income housing can break their lease if they have been accepted into subsidized housing or other housing for low and moderate income individuals. Written notice must include a statement that shows that the tenant has been accepted into such housing and intends to move there. So again, so this is just a slide for those audience members, for those prospective clients of ours or current clients of ours who happen to be tenants who are considered seniors, so over the age of 62, that it seems that they can also break their lease if they are moving into a care facility, such as a nursing home, assisted living facility, or continuing care retiring community. But the notice that they provide must contain either a statement from that tenant's physician saying that they're in need of those services and proof that the tenant has been accepted into the facility. Likewise, for those who are not already living in low or moderate income, you can break your lease if you've been accepted into subsidized housing for other, or other low or moderate income housing. But notice must be provided as well that proves that you've been accepted into the housing and that you intend to move there. David, have you had an experience in your practice in the years that you've been doing tenancy law? Do you come across this as a subject ever?
Actually, no. And I'll tell you why. Because the reality is, I'm certain that there was a need for this portion of the statute, but it never comes up because most often what happens is folks, seniors specifically, when maybe they should be moving into a place that will provide them a higher level of care, right? Call it nursing care, call it a nursing home.
Mhm.
They don't want to go. Most often they don't want to go because that's an acknowledgement that maybe they need help. And so the reality is mostly it's landlords trying to possibly evict them for other reasons
Oh, wow.
that are not, they're sort of beating around the bush. And so I can't say, I've seen, again, in the instance of a spouse who passes, that's one thing, but I've not seen it where landlords put up a fight over something like this. There's another really big reason why, and if I can give that, and I'll just be brief.
Sure.
For those who are receiving Social Security income, right? If a landlord or any creditor sues someone who receives Social Security income, that income is, generally speaking, exempt from a landlord's execution. So what that means is if you get Social Security and your landlord sues you for the balance of some rent on a lease that's owed, they may be able to collect a judgment against you, but they may not be able to touch your income.
Oh, wow. Okay. Okay. That's
Right.
good.
So many times seniors who only have Social Security income, we call them collection proof because the landlord just may not be able to touch them.
Right. Right. Okay.
That's not in every circumstance, and that's not for every type of creditor, but it is for a landlord.
Sure. Sure. Okay. Very good. Yeah, and that seems to be like a very and it doesn't seem like it's come up in your practice particularly often, but important, certainly important information to have. And it's certainly important information for those audience members who either are senior citizens themselves or who might have family members who are senior citizens who might need that additional care. That's something that is certainly very valuable to know in the event that they may be enjoying a lease term right now, but you may have some trepidation or some apprehension about breaking that lease. But there are some remedies there, and then there are some protections there. So really helpful information, and I hope that that serves that purpose and helping in that particular endeavor. So and then likewise, we also have tenants with a disability and housing that is not accessible. So tenants with a disability may break their lease if the landlord, after notice, has failed to make the dwelling accessible. Written notice must be given to the landlord in advance of the intent to terminate and must contain a statement from your physician that you are permanently disabled and proof that requests for accessibility was made, but the landlord was unable or unwilling to do so. So, David, is this kind of similar to like I'm trying to draw like a comparison to a habitability claim where constructive eviction is a remedy. Are those analogous kind of circumstances whereby someone has put the landlord on notice, similar to a place that's in a state of disrepair? But here, let's say we have someone who needs a handicap accessible living arrangement, someone who has a lifelong permanent disability, and has put the landlord on notice that, hey, I need these repairs made, or I need these accommodations made, and they fail to do so. Does it follow the same procedural, flow or process that you outlined for us with constructive eviction?
I think the answer is yes, right? I think the simple answer is yes. I think yes and no. What folks who have a disability may have had that disability their entire lifetime, but I think the ones that are the cases, fact patterns that are more egregious is when someone becomes disabled, right? They're in a car accident. In a car accident, maybe have an amputation, maybe they're now wheelchair bound, right? And they can no longer get up to the second floor in a apartment building that only has stairs and no elevator, right?
Right.
So something else changes, right? Someone has diabetes and maybe has an amputation, and there's a small step to get into the doorway is built on a small step. They can't lift their leg to get over the step. They can certainly ask for what's called a reasonable accommodation, but generally speaking, if the landlord can't accommodate them because they have no apartments that are like that, or they literally all the apartments on the first floor are taken up, that might be a way or a reason for someone to want to get out from underneath that,
Right.
away from that lease, out from underneath that landlord.
Gotcha. Okay, very good. And if they decide to leave, and it sounds like the connection here that I just want to be clear about, if either the property is unable to accommodate that need, or if the landlord flat out refuses to, are those legal or defensible grounds for breaking that lease?
Yes,
Okay,
yes.
excellent.
And I would submit even further, the if you submit a reasonable, this paragraph sort of hints at it but doesn't quite get it, right? Proof that request for accessibility was made, right? But if you make a reasonable accommodation request, that's a term of art. And under the New Jersey law against discrimination, against the Fair Housing Act, and probably one other big body of law I'm thinking of, right? If under those three acts, if you make that reasonable accommodation request and the landlord just flat out ignores it, right? You now have a cause of action, a reason to file the landlord federally. And so that usually scares them a lot. And so they'll usually, it'll come to a head. Hey, we can do this to make this apartment work, or there's nothing we can do to make this apartment work. You need an elevator. We don't have any elevator. It's an old building. Therefore, we'll let you out of your lease if that's what you want to do.
Okay.
I don't, to be fair, I don't see a judge in the land saying, landlord, you must now retrofit an elevator. I don't think that's likely to happen, but
I see. I see. But the remedy tends to be that then you are out of your lease or something like that for the tenant who's seeking that accommodation.
right. But I generally think that those are done like some will go to court, but I think those are done way more informally.
I see. I see. Okay. Very good. All right. We'll go ahead and we'll move forward. So the New Jersey Safe Housing Act. So again, this just expands on what we were talking about earlier with regard to domestic violence. So just to kind of briefly touch on what's written in the manual with regard to the New Jersey Safe Housing Act, it's a law that allows domestic violence victims and or their children who are tenants to end their lease before it is over. And the purpose of the law is to help victims who are tenants find safe long-term housing. So under the law, a tenant must give the landlord written notice to end the lease early, and the lease will end 30 days after the landlord receives this notice, and you are required to pay the rent until this 30th day. But the notice must tell the landlord that staying in the leased apartment or building will cause the victim, tenant, or the tenant's children, or any child to face an immediate threat of serious physical harm from another person, and that the threat of serious physical harm comes from a specific person, not just a generalized threat. But as you said, David, that it doesn't have to necessarily have occurred in that particular domicile or that dwelling or that residence. It could have happened elsewhere, right?
That's correct. But it's really more about that likely, your abuser is the person you lived with, and they know
Okay.
exactly where to find you in the future, where you lay your head at night.
Okay, great. Thank you for making that connection. So again, that being the purpose of the law is that it's to protect the tenant from an aggressor or an abuser from finding them and putting them potentially in harm's way. But it sounds like, at least per the manual, that in addition to the notice itself, there's some additional evidence that is required. So, some examples of documentation that helps, I guess, bolster or solidify or verify that notice is things like a certified or official copy of a FRO, either from New Jersey or another state, a certified copy, or excuse me, a law enforcement agency record documenting DV in the past, notes or reports of a doctor or a nurse or other healthcare provider from a hospital or emergency room or private medical office describing injuries from the DV, written certification from a certified DV specialist or director of a designated officially recognized DV agency stating that the tenant or a child of the tenant is a victim of domestic violence. And then, of course, other documentation or certification from a licensed social worker that the tenant or a child of the tenant is a victim of domestic violence. So, and I think it's important to note too that when it comes to like a physician's letter or a social worker's letter, that they are qualified individuals as well. Um, and David, do you have any experience in your years of practice? Have you ever, via your representation or your work in the capacity of legal services, do you ever engage or interact with any of these kinds of cases? Do you see these often?
Yeah, the answer is yes, I have. I've done so. I'm going to say maybe just 2 or 3 times. Well, I remember the first time we did it, I was amazed because the landlord's like, "Okay, then I guess you're free to go." The second time, the landlord fought it out more, but as soon as we had provided them a copy of the final restraining order, they just rolled over really that quickly, right? They're just, once if you give it any thought, it's somewhat obvious that you can't. There's got to be a methodology to get folks out so they can be safe.
Yeah.
And if you don't, keeping them there, forcing them to stay there because maybe that's the only place they have, and if they spend their rent money there, they can't go elsewhere. It's putting them at continued risk going forward.
Yeah, that is such a great
And
observation.
and I think what's important too is so many times, right? What happens is when there's domestic violence, if the police are called, maybe it's almost always men, and so maybe the fella gets locked up, right? But he's not going to stay in jail forever. Right. And so this limited time frame, a limited 30 days, right? I would encourage people to, if this is their circumstance, to really give that notice to the landlord almost immediately, because when the fella comes out of jail, if you're already gone somewhere else, that's going to keep you safer.
Right. Yeah, it's such an important and point to have. Now, we at Family Promise, we're not a clinical agency designed to, counsel abused clients, but we do have wonderful area services in Sussex County. We have Daisy, And then in Morris County, I believe there's JBWS, and there's
Correct. That's the Jersey Better Women's Shelter. They're really good.
that's excellent. Yeah, and they provide some really phenomenal services there. So for any of you who are watching this and need that particular help and that particular counseling, please reach out to those services. I do have I will stick around here for any questions that you may have. We can provide that contact information if you need it for anybody who needs to reach out to us, and we can make those referrals. Family Promise of Sussex County, our main intake line is area code 973-579-1180. I please, and I really encourage you to call, whether it's a legal matter or whether it's a housing matter or any crisis that you're in. If we can't personally solve that problem for you, we will make the proper referrals and connect you to the area services that'll be so helpful. And our final class in this series of landlord-tenant classes, our last class is going to be area resources. And we're going to talk about the different area social services, and of course, including legal services of Northwest Jersey that are available to help you in these different circumstances. So if you are in these situations, please reach out to somebody, seek help as immediately as possible. And there are remedies for you. So don't feel apprehensive or trepidatious or be worried that you are not going to have some kind of solution to your problem. We can try to help you. So I wanted to make sure that we let that know and we address these situations with the utmost sensitivity, confidentiality, and care. Okay. Some extra points that I just want to make with regard to the New Jersey Safe Housing Act. Once that lease is terminated as a result of proving a danger from DV, the security deposit should be returned 15 days after the victim is out of the unit. For those in subsidized housing or public housing, housing authorities should help the tenant who lives in subsidized housing move to another unit or evict the abuser. And landlords are certainly required to keep all of your personal information private and confidential. And one thing I wanted to note that I found, also in there as well, that the victim tenant is responsible to pay their rent until the 30th day. But one important thing to note is that if there are other tenants on the lease, the other tenant's lease also ends per the manual. The other tenants may enter into a new lease if the landlord chooses. The other tenants should not be removed from the home unless the landlord has good cause under landlord-tenant laws. So, but I want to make sure I'm not confusing anybody who's reading that, because in one sentence it says that the other tenants, so if there are other tenants on the lease, the other tenant's lease also ends. And then it says the other tenants may enter into a new lease if the landlord chooses. But then it also says the other tenants should not be removed from the house unless the landlord has good cause. So it says if the landlord chooses, but then if the landlord has good cause. Are you able to help rectify those two statements, David? Or is there a simpler way to explaining that for other tenants who are in the household and there's someone who's abused and they have to be relocated because of that past abuse and any danger to their person or their child? What about other tenants who may be in the household? How does that work with them?
So if they, generally speaking, the entire, as you indicated, under this statute, they can get rid of the entire lease, right? Again, if it's a traditional male-female relation, it doesn't have to be anything. But usually what happens is the abuser might be locked up, right? And so the landlord may not want to try to hold him, if it's a him, responsible or to come back. As it relates to the female, she, again, looking out for her safety. If there are other roommates, in theory, if they wanted to get off, they could, or they could, as you indicated, they could, enter into a new lease if they were able to make the payments. But frequently, what happens is if usually in an apartment setting, everybody's got a responsibility, and so if 2 out of the 3 or 4 or 5 people, go away, one because she's a victim, the other one because he went to big boy jail, the remaining folks there might not be able to afford to live there, and so they can just all walk away.
I see.
But if there is good cause required, that what they mean by good cause is the 17 reasons found under the Anti-Eviction Act that are suitable to evict a tenant.
Okay. All right. Very good. All right. Well, I think that pretty much wraps it up. So, folks, for those of you who have joined us for this session live, again, I thank you for your time. I thank you for watching this, and if you're also watching it, after it's been edited and put up on our social media, and you enjoyed the entire material from start to finish. And David, you've certainly made it super interesting and engaging and thoughtful and so thorough, and your responses were excellent. And really appreciated your time and your expertise and devoting your evening to educating our audience. It is so invaluable. And I can't thank you enough, not only for attending this session, but also for the excellent work that you and your staff at Legal Services do day in and day out, fighting and advocating for the clients that you serve, and certainly the consumers that we have here at Family Promise, because a lot of those consumers and those clients, they intertwine with each other. And the service you do are just absolutely incredible. So thank you again for your time this evening. It's been much appreciated and really informative.
No, you're welcome, Frank. You're welcome. We're just thankful to have you around, and together we all work together to try to help folks out. So we're really pleased to work alongside you as well.
For sure. So guys, if you have the time, I recommend go ahead and scan this barcode right here, and go ahead, take the survey. Let us know what you thought about this evening's class. Let us know what you think about STEP in general, and any improvements we can make, or if you enjoyed it, say you enjoyed it. And we're happy to have that. And we also, want to leave room for questions before we jump into that. This is again, Dawn, in making these slides, she really puts up these very thoughtful quotes. So you can have more than one home. You can carry your roots with you and decide where they grow. I think that's really beautiful. So appreciate that from Dawn. Very insightful. And she put these slides together. So she's done an incredible job of breaking down some of this. Some of it can be rather complex, and sometimes, dry material. For those of us who aren't, really enjoy the law and are super interested in it, but what she does is she breaks it down and simplifies it. And likewise, hearing David, break it down for us as well has been really helpful. As we go back to, I just wanted to check the chat and make sure that there weren't any unanswered questions in our live chat. I think we're okay there. So David, I'm going to go ahead and conclude for the evening. We are all wrapped up. And again, I just wanted to once more thank you again for your invaluable contributions to this evening's course and your continued work with Legal Services. We look forward to having you back again as a guest, and the rest of your staff. And thank you again to Randy for his previous contribution to our habitability course. Mr. Tolentino from your office is going to be joining us as well. So we look forward to those future classes, and thank you once more. And I hope you have a wonderful evening. You as well. Bye now. All right. And again, thank you for those of you who have stuck around and enjoyed STEPP, Stabilizing Tenancy Eviction Prevention Program, our landlord-tenant legal series, which has been funded by the New Jersey State Bar Foundation. A really great opportunity to speak with legal practitioners and learn from other area service providers and just get that great information out there. I hope it was really informative. I hope you guys enjoyed it as much as I did. It was really great. Thank you again to David, Legal Services of Northwest Jersey, and again, the New Jersey State Bar Foundation. This is Frank Sawicki from Family Promise of Sussex County, saying good night. Thanks again for joining me. And thank you to Tori. Tori, our excellent tech. So she ducked out, she dipped out of here, but she's here to help me in a tech capacity. But she's just so pleasant and nice. She stuck around for a little while, and once David came on, I had less stage fright because I was like, "Oh, Tori, no one's here. I can't do this on my own." So she stuck around and helped me out. And then, once David got here, I was like, okay, scram. No, I'm just kidding. She's excellent. She really is lovely. And I hope she joins us again next week. So thank you, Tori, for all your help. I think this is the first time I've done this video where the tech has actually worked out, and it's 100% because of you. So thank you very much for that. Thank you to everybody, our participants, our audience, everybody. So have a wonderful night. Thanks again. Bye.